In 1966, an engineer at a defense contractor in New Hampshire had an idea that his colleagues thought was a waste of time. He wanted to make a television do something it was never built to do: play a game, not show a program. Play, he wired a box that put 2 dots and a line on the screen and let 2 people knock a 3rd dot back and forth. He called it the Brown Box. His employer licensed it to Magnavox, and in 1972 it became the first home video game console. His name was Ralph Baer. And over the next 20 years, almost every company that built a video game in America would end up paying him, because Baer didn't just invent the video game. He patented it. Here is what makes this case different from almost any other in this series. Most inventors fight to defend a narrow claim: one device, one mechanism. Baer's patent did the opposite. United States Patent 3,728,480, titled Television Gaming and Training Apparatus, issued in April 1973, did not protect a particular circuit. It protected the idea of generating symbols on an ordinary television screen and letting a player move and control them. A companion patent, a reissue, claimed the part a jury could actually picture a symbol controlled by the machine that a player-controlled symbol could hit, so that it changed direction, a ball you could bounce. Read that broadly, and Magnavox read it as broadly as it would go, and it covered not one game but the entire category. Any dot on any television that a person could steer. The patent office had granted that, which meant that the question facing the young video game industry was not whether some company had copied some specific design. It was whether one man owned the act of playing a game on a television at all. On the 24th of May, 1972, a man named Nolan Bushnell walked into a Magnavox dealer showing in Burlingame, California. He played the Odyssey's table tennis game, 2 paddles, a bouncing dot, and he signed the guest register on his way in. Months later, Bushnell founded Atari, handed an engineer named Alan Alcorn what Alcorn understood to be a practice assignment, and out of it came Pong. Pong was a sensation. It also looked a great deal like the game Baer had built. In April 1974, Magnavox and Sanders sued Atari, and a long line of others making coin-operated and home versions of the same idea. The defense across all of these cases was the one inventors always faced: the patent is too broad, it's obvious, you can't own bouncing a dot. And there was prior art to point at: Space War, the famous game built on university computers. Even an oscilloscope tennis game from 1958, surely Baer wasn't first. But Magnavox had something the defendants underestimated. It had the patent, granted and on the books. And it had a guest register from Burlingame with Bushnell's signature on it. Proof that the founder of Atari had stood in front of the Odyssey and watched the very game his company would go on to sell. Bushnell would always insist Pong was his own. The courts were not asked to judge his conscience. They were asked to judge the patent. Atari did not wait for a verdict. In June 1976 it settled, paying Magnavox $1.5 million for a perpetual license to the patents, and agreeing to share its technology with Magnavox for about a year afterward. Then came the case that set the rule for everyone else. In January 1977, in federal court in Illinois, Judge John Grady ruled on Magnavox versus Chicago Dynamic Industries. He upheld Baer's patents. He found the defendants' games infringed. And he treated the work as what Magnavox had claimed it was all along: the pioneering patent of the video game art. The prior art defenses failed. Space War and the oscilloscope game were not enough to undo it. After that ruling, the pattern was set. Company after company, Coleco, Mattel, Seeburg, Activision, either settled or lost. By common estimate, Sanders and Magnavox collected over $100 million across 2 decades of litigation. They did not lose a case that went to judgment. The last serious challenge came from the company that would define the next era of the industry. In 1989, Nintendo went to federal court in New York to have Baer's patents declared invalid, arguing Magnavox had hidden prior art. Space War again, the tennis game again when it applied. The court ruled against Nintendo. Nintendo had not proven, by the standard the law demands, that anything was concealed with intent to deceive. The patents held, and then they simply ran out. By the early 1990s, the term expired and the toll booth came down. For roughly 20 years, though, Ralph Baer's name sat at the foundation of an industry he did not build and largely did not profit from directly. The money flowed mostly to Sanders and Magnavox. Baer himself received the National Medal of Technology in 2006. He is buried in the record as the father of the video game. And here is the lesson this file leaves on the table. In our first case, Robert Kearns owned something narrow and spent decades proving it was even an invention. Baer's problem was the reverse. His patent was so wide that owning it meant standing at the gate of an entire industry and charging everyone who walked through. The lone inventor did not get crushed by the corporations this time. He became the thing they all had to pay. A broad patent is not a bigger prize. It is a bigger target and a bigger toll booth, for exactly as long as the law lets it stand, and not one day longer. Next time, an inventor who gave his patent away on purpose, and what that decision cost the people who came after him.